Hello, and welcome back to Coin Lady channel. I'm going to offer some of the latest insight from attorney Jeremy Hogan, and you're going to love it because Hogan stated, quote, "The possibility of settlement in this lawsuit just got up 10 times. And in court, and this is fascinating because most attorneys, including attorney Hogan, appear to anticipate that there is going to be some appeals going on in this case. Attorney Hogan does not. Judge Torres' decision to turn the requests for summary judgment away in favor of Ripple and XRP holders has increased the chances of a settlement, and he believes no appeals will be filed as a result. But wait, there's more good news. However, that's not all. Referring to page 15 of Judge Torres' order, he added, in terms of the legal status of XRP, which of course, it's absolutely not a security. And she says, and I'm quoting loosely here, "We can look it up, this is something I've talked about a million times over the past week." The token itself was what she discovered. Attorney Hogan has stated that he does not believe that XRP meets the stringent standards, meaning that it is not a security, and that this is not something that can be appealed. Sure, there's a lot to discuss here. But he means it literally cannot be appealed from a legal standpoint. However, I should state up front that I do not come from a legal or financial background. I am not qualified to provide legal or financial guidance. Furthermore, you should not make any financial decisions based on what I say. I'm just a fan who occasionally posts videos to YouTube discussing random crypto-related things for kicks. Okay, so here's a section of the crypto basic game. Top: a U.S. attorney claims the odds of a settlement between the SEC and Ripple have increased by a factor of 10. In what is being called a major victory for Ripple, the court determined that XRP is not a security, and since then legal experts have been speculating on the next steps in the SEC versus Ripple case. The company's programmatic XRP sales on exchanges, it was claimed, do not amount to an investment contract and are therefore not securities. John Reed Stark and Mark Fagel, two prominent securities attorneys, are among those who believe the SEC will appeal the court's decision and that the Second Circuit would reverse it. Therefore, look, I have no idea what will occur. Most lawyers seem to think that an appeal is inevitable, but speaking as someone who did not go to law school, I find attorney Hogan's argument for these parties not appealing to be the most compelling because the SEC stands to lose so much if the appeal does not go well. This is because we are talking about binding precedent from the Supreme Court. And what do they gain if things do turn out in their favor? Just so you know, all this seems like it wouldn't even convert XRP from an unregulated asset to a regulated security. Furthermore, in reality, the opposite would occur. What's more, I'll tell you right now how I feel about the XRP concept. The assumption that the ruling cannot be challenged on appeal stems from the fact that the judge was given clear and complete instructions on the issues at hand. Well, there are a few things to consider. The question of whether or not XRP itself is a security was not one she was required to decide. So, she did express a strong opinion on the matter. In addition, there are legal ramifications. This is the law, but it's Dicta de ICTA, which means it was decided by an international tribunal. Legal professionals will recognize the word. Furthermore, she was not assigned to make a decision on this matter. Nonetheless, its staying power is interesting. Given that this is merely dicta and not a matter on which she ruled, attorney Hogan said that the SEC would be out of luck in appealing the matter. To me, this is doubly hilarious since, in my opinion, the SEC invited this by overreaching and throwing forth this fake bullshit BS embodiment theory, which had nothing to do with what the case was ultimately about. They said that the Howey test was passed since XRP represents those initiatives from Ripple. You do remember that, right? Well, wouldn't the judge rule that XRP fails to meet the How criteria? Without the SEC putting her in a situation where she could, I doubt she would have gone out on the ledge to say something like that. I find it beautiful that the SEC has been in this trap of their own creating since year 2. What I mean to say is, For his part, pro-XRP attorney Jeremy Hogan maintains faith that the parties can come to an amicable resolution thanks to Judge Torres's declaration of XRP as a non-security. Yesterday, in an interview with Darren Moore, Jr., attorney Hogan indicated that after the judge determined that XRP is not a security, the parties' odds of settling had increased by a factor of 10. Hogan said the SEC's demands are why the parties have not reached a settlement. One of the SEC's possible demands, he said, may be that Ripple register all of its future XRP transactions with the SEC. Hogan, the SEC's request would be detrimental to the operation of the Ripple's business. Yeah. Let's take a moment to process this. And it could, I don't know. But let's give this some consideration. To begin, I'd like to mention that XRP was developed in part by David Schwartz, CTO of Ripple. And the XRP ledger has publicly stated that he doesn't think that this is going to impair Ripple's business model, but I am not privy to all of his reasoning for thinking that way, having observed that, at the time, they were still kind of internally looking through this to see what made sense. To be clear, this only affects the institutional sourcing of XRP. On-demand liquidity using XRP as a bridge currency is not affected in any way. What happens then if users of Ripple's on-demand liquidity service buy XRP from a company that is not Ripple? From what I can tell, that wouldn't change anything. I also have a question, by the way. Since Ripple also offers XRP leasing, this is the case. Is that even considered a sale, or do I need to rethink my assumption? Perhaps even though there was some sort of purchase, quote-unquote, perhaps since it's just a lease of the XRP, the ownership doesn't transfer? And then one must return it or make restitution. I can't place the scene in my mind. The necessary paperwork is clearly very secret, therefore I haven't seen it. Because of this, I can no longer claim ignorance. And even if I had the documentation that Ripple had its customers sign in order to receive a lease of XRP, I'll still tell you this. Even I would still need legal advice, even if I had that, because of the potential legal ramifications. I'm only suggesting that maybe there are ways to avoid that. Plus, I'm pretty sure there are, so there's that. It might make it more challenging for Ripple to continue running their company as usual. However, this does not necessarily indicate an insurmountable obstacle. They might be able to sidestep this obstacle with relative ease. Leasing, which they were already engaging in, could be a component of this solution. But it can be as easy as buying XRP from another person and routing it through this site. I don't see why not. Anyway, the truce holds. In addition, Hogan stated that the odds of an agreement between the parties had increased by a factor of 10 as Judge moved towards his decision that XRP is not a security. Here's what Hogan had to say about it. From Thursday until today, the possibilities of a settlement in this case increased by a factor of 10. Now that we have a non-security designation, things may alter, and we'll have to wait and watch what happens in court as a settlement may be in the works. I certainly hope so, as this course of action is far preferable to filing an appeal. We'll find out in due time, but even if the SEC files an appeal, I've already gone over this, so I won't bore you with the details, but if they're already trying to file an appeal, it's called an interlocutory appeal. Because it's highly improbable that she would prove that the trial is over before you appeal, you're asking the judge to speed up the process so you can file your appeal immediately. Do we really intend to hold off until it has concluded? Then why is there still a case for it? Not at all, please. That happens as quickly as possible, please. Because the SEC lost, even on the minor bit where they got to win on the institutional side, this settlement is meaningless in practice. There's no way this will hurt the XRP market, and even if it did, XRP holders wouldn't care. What I mean is that they appear to be in a pretty bad situation. It appears to be that way. Hogan also mentioned that this was the SEC's first defeat in a crypto-related action it has initiated. And he said that he doubts the SEC was ready for that. Absolutely, in my opinion. He says the SEC probably thought they were going to win the lawsuit. I agree with Hogan that the SEC is run by arrogant spawns of Satan, and I think that this is an example of his thesis. So, once more, Hogan doesn't anticipate any appeals to the lawsuit, but, he could be wrong. As a layperson, I am not as convinced by the arguments of the other attorneys who disagree with me. However, there is one thing that, in retrospect, I believe to be self-evident. This was the argument that Attorney Hogan was making. Strategically, the SEC's pursuit of Ripple was a tremendous misstep. And, he said, if Ginza had been in charge of the choice to sue or not to sue Ripple in late 2020, he doubts she would have initiated the action against Ripple, at least not at that time. Although the SEC has demonstrated a consistent litigation approach under Gensler's leadership, Hogan is of the opinion that Gensler, given the choice, would have pursued the easiest targets first. By the way, I should clarify that the term coherent litigation strategy does not imply that the approach is good or reasonable, rather, it is horrible, offensive, and revolting. There is no sense of right and wrong in that at all. But it is a coherent strategy, which is basically, at this point, to go after the exchanges, go after the on and off ramps, because then you don't have to worry about the tens of thousands of projects out there, because, as Attorney Hogan noted, it's like playing whack-a-mole with all the projects that are out there. Instead of taking the indirect route, you go straight for the throat. And so, what's likely is that guns are what it just, if you were going to try and get legal precedents that have anything outside of the strategy that I just cited in terms of, the on-ramps and off-ramps and going after exchanges, he would have tackled rather than Ripple, much smaller projects to set legal precedent. However, taking on Ripple when they have over $1 billion in the bank is no easy task. Was not a very astute choice. Not a very astute move. But that's exactly what Jay Clayton did, and that's not a good idea, especially because they're already breaking the law about dams. If your opponent is particularly formidable, you may find it more difficult to persuade the judge to rule in your favor. And in this situation it was the SEC going up against Ripple, yet several of Ripple's lawyers have prior experience working for the SEC, including a former chair. That's the name of one of the lawyers retained by Ripple. In other words, it's a case of the SEC versus the SEC. What do you think is going to happen between the criminals? Let me just say. In other words, this is lovely stuff. But yeah, my favorite part is that Attorney Hogan says, I don't see how from a legal perspective, you can appeal the part that matters, which is as flatly that XRP itself is not a security. This is because the judge wasn't ruling on whether or not XRP is a security. That was her observation. Simply put, it's dicta. Even so, it is law, but in his professional judgment, there is no possible way to appeal it on legal grounds or even on a technicality. This is music to my ears, and I love it. You shouldn't buy or sell anything based on what I say because I'm not a financial expert. Please like and subscribe my channel. See you later, bye.